Welcome to what may well be a seminal episode of the Agents Angle in terms of news for the football agents world. With me, Jonathan Booker.
And me, Peter Paleologos. After an injunction in Germany, a block on commission caps in Spain, we now see a ruling in England that could force FIFA into a rethink over their new FIFA football agent regulations.
And whilst the decision in England has been a long-running saga over 5 to 6 months, we examine why it may have taken so long.
Plus, we look at the way forward with agent regulations and the ramifications of this decision, not just for England, but around the football world.
All that to come on this episode of The Agents Angle. So for probably 2 months now, we have been anticipating the release of one of the most important rulings in regards to the new FIFA football agent regulations, the FFAR. And we have good news, well for most, as we have a decision in England on the FFAR through the Rule K arbitration process. Now this news dropped approximately 2:30 PM UK time on the 30th of November. So that's roughly 18 hours ago at the time of recording, and information is still a bit patchy as we await details of the full ruling. Plus, we are not entirely sure how much information will be released in regards to the arbitration proceedings and the findings, as they're often subject to confidentiality on certain matters, as with other forms of arbitration. However, I will leave it up to my esteemed legal friend to try and sum up what we know so far. Peter, over to you.
I'll firstly admit at 2:30 PM UK time, I was sleeping here in Melbourne, Australia, and got up and the phone was full of messages. What happened in England overnight? We don't have the Rule K full decision yet to unpack. However, I want to actually go to the Football Association media release that was released earlier today. I'm just going to read it very briefly. On 30th of November 2023, the Football Association Rule K Tribunal issued its award following the conclusion of proceedings, which declared that if the FA implements the fee cap and the pro rata payment rules in their national football agent regulation, it will be a breach of the United Kingdom Competition Act of 1998. The full arbitration award remains confidential at this stage, but will be published in accordance with Rule K11.3 of the arbitration process or arbitration rules. Until that time, no further details can be provided. The Football Association is considering the implications of this decision and will provide a further update as soon as it is able. And that's been published by Football Association staff. Now, it mentions Rule K11.3. This is more about the publication process. And our guest today will cover that aspect a little bit more fully, how these decisions are published. But as I said, Jonathan, we do not have the full decision, so we can dissect it. We know that this arbitration challenge was brought by 4 of the largest agencies in England against the FA and the implementation of the National Football Agent Regulations. It basically was pretty much an expedited hearing, but it wasn't decided by the 1st of October when the FIFA Football Agent Regulations came in. Now, I'm not surprised with the decision. To put it simply, it's pretty much a high competition law claim. Now, I had a look at the United Kingdom Competition Act 1998. It's very similar to the Australian Competition Law Act, where decisions or agreements by associations of undertakings that affect trade in the United Kingdom, and that decision or that practice or that has the object or effect the prevention or restriction or distortion of competition with the United Kingdom, then it is illegal. Now, there is ability to apply for an exemption to be able to have, for example, in this case, fee caps from the Competitions Commission. But basically, in this case, it was seen that the aims or the objects of the fee caps and also the way agents were going to be paid was a restriction on competition within the United Kingdom. I think that's the way the tribunal or the arbitration tribunal would have read it. Very similar to what happens in Australia. And to be able to do something to say, for example, like a fee cap, and we know that only governments or maybe legislatures can put caps in, say, on increases in rent or medical insurance premiums. They need to legislate and make those decisions. But in this case, we know that the tribunal decided that the cap, as well as the way agents are going to be paid, the 4 installments, for instance, is illegal. It's a restriction of competition within the United Kingdom, Jonathan.
I think at the front end of all of this, there's a lot of people asking the question, what's going to happen next? And the simple answer is, we don't know. There's a lot of people jump into assumptions and trying to guess what will happen next. We simply don't know. We're not going to try and guess. But later in this episode, we're going to try and have a look at the draft NFAR, the National Football Agent Regulations that the FA in England released prior to this Rule K arbitration process commencing. And I think this was late July. They released this to a quite small and select group. However, this document does give us a few clues on what the FA may try to implement in terms of new national football agent regulations going forward following this Rule K decision.
Yes, we need to distinguish that in Germany there's an injunction, so the FFAR or the National Football Agent Regulators can't go ahead. In Spain, it's the cap. In England, it's the cap and also the way that agents are supposed to be paid. Now, some agents in other countries will say England, Spain, Germany, the agents there don't have the caps. We do. Is that fair? I will say one thing. The very interesting thing about this decision is not just the caps, but also the payment terms. That was found illegal to have such payment terms on agents where they had to be paid in installments. Now, that doesn't mean that agents can now say, okay, I want my money up front or whatever, because we have to take into account that the agent business, there are other things we need to look at. How clubs' budgets are, the player trading strategies, contracts, when a player is getting paid or receiving their money. If there's outstanding players not getting paid, the agent may not get paid. So this has really an implication, I would say, for transfers. It's just because the cap's gone and also the way agents were going to be paid in England, understanding the club's finances is also very important for agents. Now, I'll just mention very briefly, we know that we had Brexit. So how is the other big case that's coming up probably next year at the European Court of Justice, which would be the ultimate ruling for Europe? How does that affect this? I think the European Court of Justice will be probably the most important case, not because Europe is a bigger market. We know England has the most fees for agents, but I think in terms of the European case, most countries will be guided what happens there. We don't know where it's going to go. We know it's focused on competition law, just like the English Rule K arbitration. However, it's the European Court of Justice will ultimately decide the implementation of caps and the rules generally. So that's the position at the moment. Now, finally, what's FIFA going to do next? We know there's a FIFA agents working group is meeting in Saudi Arabia this month, 15th of December, and that's going to be a pivotal meeting, Jonathan. I think
I'd love to be a fly on the wall at that one. That's going to be fireworks, I think. I'd love to be a fly on the wall at that.
Yes, and I would say that several agent organisations, I know that European Football Agents Association are represented there, the African Football Agents are represented there, the South American agents, UEFA, are represented there, PROFA as well, who ran the CAS arbitration. But I assume they're going to put alternative proposals re the cap implementation. I think all those organizations should step up and put alternatives to say, look, it's a fractured situation. We need to deal with this with urgency. And that meeting is pivotal. I will say this, if you recall...
The thing is, Peter, that some of those organisations we know have already put forward alternatives going back many, many years, and it's FIFA who have chosen not to listen or not to consider and not to hear those concerns. And now the birds are coming home to roost. A lot of those associations who will be represented at that meeting have presented these alternatives over many, many years.
They have. And if you recall, there were several draft versions of the FFAR. And in the second version, there was an exception to the caps. So there were caps, like we have now, 3, 5, 10% or 6%, depending on where you're coming from in the deal. But there was an exception in the second version of the FFAR where agents can charge a fixed fee, a lump sum, like a lot of lawyers do, an hourly or daily rate or monthly or some other retainer. And there was no really a maximum there. It was just a reasonable amount. And that was removed. I wonder if that was still in place, whether the cap decision would have been decided that way, because it wouldn't have been a full cap. You had other options to get paid. Now, I will say one final thing here. This is an important decision because even though we've had Brexit and it applies to England, we know for international agents, ever since the governing body endorsement rules have changed, what kind of players can come and get work permits in England, The regulatory landscape's changed. Obviously, England's a very important market, but a lot more international players have had a chance, especially from South America. And they will see this as a good opportunity because there's no caps to push more players. So agents from the outside are looking in on this decision as well. And I will say one final more thing. Scotland's also got a Rule K arbitration. We haven't seen anything from them, but this decision that's happened in England will obviously have a big impact on what Scotland decides about their regulations and, of course, the cap.
Absolutely right. And it's important to point out that that is a separate arbitration procedure. A lot of people are reporting that this decision in England applies to the UK. It does not. It's a separate process. It's a separate association. But Peter, you mentioned the B word, Brexit. And if there is anything I could do without hearing again, more than FFAR, it would be Brexit. And I think a lot of people in the UK agree with me on that. However, a lot of people have been quite frustrated by the delay with this decision in the Rule K arbitration process over the agent regulations. And that's understandable, as it's put businesses in limbo and livelihoods at risk with a certain amount of uncertainty. But if it is competition law based, as you pointed out, this is a pretty complicated area. So for me, this is very welcome, as I expected. I'll be quite honest, I expected a further delay. Maybe the ruling in Spain moved things along a bit here. But moving away from the actual decision for a while, I think it's important we need to understand the process that has been applied here, namely the Rule K arbitration process. Because much like I have a hugely frustrating time explaining and correcting people on what mediation is, the same is true of arbitration. And the Rule K is a form of arbitration process. The Rule K arbitration process can be a confusing arena to be subject to, and it is something agents may well find themselves involved in at some point when it comes to English football disputes with other football participants, whether it be players, clubs, coaches, or indeed other agents. So to allow everyone to get a better understanding and appreciation of what Rule K is, how it works, and possibly some inclination as to why the decision over the FFAR and NFAR in England may have taken so long, we really need an expert on the subject to guide us through. So with that in mind, I'm very glad to be able to welcome Joe Bryan to the show to help us with various aspects of the Rule K arbitration process and clarify many of the questions that agents and others involved in English football may have. Joe is a barrister with Littleton Chambers and was called to the bar in 2015. And he represents clients in employment tribunals, the civil courts, and in sports and commercial arbitrations. Joe also sits as a chair of the FA's National Serious Case Panel, adjudicating on all types of serious disciplinary cases in grassroots football, which further highlights he not only is qualified as an expert on football disciplinary matters, but also cares about the grassroots game and that part of the sport, as well as the higher profile elements of the professional game. And with that, Joe, welcome to the show.
Thanks for having me.
Very welcome. If I can just start, Joe, in very basic terms, how would you describe Rule K and its purpose?
Rule K is a bespoke mechanism for dispute resolution in football. The name Rule K derives quite simply from the section of the FA rules in which the procedure itself is set out. It is at heart a type of arbitration, and arbitration is a process where a neutral and impartial tribunal adjudicates on a dispute between two or more parties. So arbitration can be thought of as an alternative, generally a private alternative, to going through the public courts.
Now, one of the biggest misconceptions with Rule K is that actual role of the arbitrators, their independence rather than representatives or, if I'm correct in saying, counsel. Can you just explain the arbitrator's role a bit more in situations such as Rule K?
Yes, absolutely. So the arbitrators are the decision makers. They hear the evidence, they listen to the representations made by the parties, they decide what the facts were, and then they apply the relevant regulations to those facts to reach a decision. And so for that reason, they're totally independent and impartial of the parties. Depending on the nature of the particular case and the parties' preferences, there'll either be a single arbitrator or a panel of 3 arbitrators. Where it's a single arbitrator, the identity of the arbitrator has to be agreed as between the parties, or if they can't agree, then there's a mechanism for the Football Regulatory Authority to select the nominee. In the case of a 3-person panel, both parties get to nominate their chosen arbitrator, and then the third chairperson of the panel is jointly agreed, failing which is appointed by the FRA in the same process. So the arbitrators are the people who decide the dispute. They are distinct from the representatives, who might be solicitors, counsel, or indeed any other individual.
I think that's one of the key misconceptions. People think that you appoint an arbitrator and they're going to back your case or fight your corner to an extent, and that's simply not the case. From your experience, what are the other misconceptions that parties such as agents have when it comes to Rule K? Are there any things that stand out?
Well, I think you've touched on one of them there, Jonathan. Just because you've nominated one of the panel members does not mean they're going to decide the case in your favour. The rules of Rule K are specific and quite explicit that the arbitrators, whoever they've been appointed by, must remain impartial and independent of the parties at all times. So they make their decision irrespective of who's nominated them. Another misconception that occasionally arises is the timescales involved in Rule K arbitrations. Lots of parties have either got experience of litigating in the public courts, or they've read in the press, particularly about the backlog that the civil courts are experiencing in England and Wales. And they assume then that Rule K is subject to the same delays and constraints. Generally not. Rule K is actually a comparatively speedy process. The provisions of the FA rules themselves set out a default timetable which gets you from appointing a panel through all the way to a hearing in just under 4 months. Now, that default timetable is subject to variation, subject to agreement, depending on the particular case. But generally, the aspiration is to have these matters resolved pretty speedily. The other misconception that sometimes arises, in my experience, is about representation. Parties often come to Rule Ks anticipating that they've got to be fully lawyered up, represented by solicitors, firms, barristers, and so on and so forth. That's not necessarily the case. The rules say that you're entitled to be represented by a solicitor or a barrister, or both or neither. You can be represented by any individual of your choice, which might include, for instance, in-house legal teams, or any foreign lawyer or any other kind of representative who you may choose to represent you.
A big aspect of the Rule K arbitration by the FA is a party being a participant. Can you just outline what a participant is in terms of the Rule K arbitrations?
Participant has a very specific and defined meaning in the FA rules, and it encompasses almost anyone with a significant involvement in football. So it includes agents, county football associations, leagues, clubs, club officials, directors, players, match officials, even employees of clubs. There is then a catch-all provision which provides that a participant includes anyone who participates in, quote, any activity sanctioned either directly or indirectly by the FA. So it's very broad indeed and potentially encompasses a huge range of figures in the industry.
Litigation or civil litigation is very expensive, especially in common law countries, Australia, where I am, the UK, of course. In terms of a Rule K arbitration, besides the lawyers that you have to pay, or your counsel or your representative, what would be the other main costs, party or participant, in terms of a Rule K arbitration?
Well, apart from your own costs, if there are any, the two main areas of cost, there is potentially the costs of the other parties. We'll come back to that point. But you've also got to be aware of fees and expenses of the arbitrators themselves. Typically, the fees and expenses of the arbitrators themselves are split between the parties. They're shared between the parties, though the tribunal can make a different order. Coming back to the point about other party costs, well, whether you're at risk of paying the other party's cost tends to relate to how much success you have in the proceedings. The unsuccessful party will generally be ordered to pay the successful party's costs. However, it must be said that under the rules, the arbitral tribunal, has a very wide discretion to order costs and apportion costs in any way it sees fit.
Now, I'm an agent involved in a Rule K arbitration. In terms of the rules of evidence and also appearances, are there any particular rules of evidence or processes in place that are unique for Rule K? And is my appearance by submission in documents, or would it be also a hearing where I would give evidence, say, as an agent if I had a matter on? Could you just elaborate a little bit about the process or the procedures for an agent in arbitration?
Absolutely. Let's start by stepping back and looking at the process overall. There are generally 6 main phases to a Rule K arbitration. Phase 1, the parties serve the notice of arbitration and the response to the notice of arbitration, which formally kicks off the proceedings. That's all paper-based. Then you've got 2, which is appointing the arbitral tribunal. Often that's uncontroversial because either the parties can agree a single arbitrator or can agree the identity of the chair, and the tribunal is constituted without much further ado. Third phase is serving the formal points of claim and the response, which is the points of defence. That, again, is a procedure which is conducted entirely on the papers. We get to then phase 4, which is exchange of witness statements. That's where the individual parties are going to have a lot of work to do, because exchanging witness statements is where you set out all of the evidence in writing that's relevant to the issues in dispute. Phase 5 is exchanging written submissions. Those are essentially the legal arguments and the submissions that are going to be made to the tribunal on behalf of both parties. And then finally, phase 6, the decision. How's that made? It can be either at a hearing or without a hearing on the papers. So if you have a decision that's suitable to be decided without a hearing and the parties can agree, then you can ask the tribunal to decide it on the basis of all the documentation that's been submitted. And in that case, you're not going to be called to give live evidence. You're not going to be cross-examined. The decision is made on the basis of the papers.
You mentioned there's a default timeline as such with the Rule K, that appointment to hearing of 4 months. How quick are decisions reached, or is that very much dependent on the case itself?
Very much dependent on the case itself, but as a rule of thumb, you can generally expect to receive a decision within a couple of weeks of a final hearing in a Rule K matter. It also depends, frankly, on the availability of the arbitrators, because if the arbitrators, as they usually are practicing sports lawyers, then they're going to be running their own private practices in addition to sitting on particular arbitrations. And so they've got to logistically accommodate reaching their decision, writing it up, sending it to the parties in amongst all their other priorities. So there are no hard and fast rules, but 10 days to 14 days is generally a rule of thumb, but it absolutely depends on the complexity of the matter.
And on that, can a claimant or one of the parties involved in the arbitration, either unilaterally or with the agreement of the other party, can they request to bring a Rule K to a halt before a ruling is made? Or is it very much the case that once the ball is rolling, it goes through to its conclusion?
Well, I think we need to separate 2 possibilities here. One possibility is that the parties might reach a negotiated settlement. And that's one way of bringing a Rule K to an end before you get to a hearing and before you get to an award. And absolutely, the parties are always free to negotiate at any stage between themselves to reach a settlement. And in my experience, actually, a large number of FA Rule Ks are launched and then resolved by mutual agreement between the parties. The other possibility that's raised by your question, Jonathan, is, can a party unilaterally pull out of the process? Well, yes, but there's a risk. The risk is if you do so at a time when you're considered to have acted unreasonably, or indeed the other party has incurred significant amounts of cost, you may be on the end of an adverse cost order against you. So if you're launching a Rule K arbitration, you need to be prepared at least to see it through. And you need to have evaluated the merits of your case beforehand, because the risks of a unilateral withdrawal are significant. But it is a theoretical possibility, at least in many cases.
Going back to the term participant and those participants who are subject to Rule K, if somebody who was adjudged a football participant was to take a dispute up through another legal mechanism, say a county court, what could be the result of this, such as football sanctions from the likes of the FA and FIFA?
Well, first things first, assuming that there is an arbitration agreement in the contractual relationship between the 2 parties, which subjects them to the Rule K procedure, then the main consequence of bringing a case in another forum, for instance, in the civil courts, would be that those proceedings would either be dismissed or put on hold, subject to the matter going back to Rule K arbitration. So if a case is brought in the wrong forum, the immediate practical reality is that that case will be put on hold or would be dismissed, whilst the case is sent back for Rule K arbitration. And that indeed is what happened in the important case of Mercato Sports and Everton back in 2018. Mercato brought the proceedings for a fee for introducing a player to Everton in the High Court. Essentially, the court held that both of the parties were participants and that they were subject to an arbitration agreement subjecting them to Rule K arbitration. And so they were bound to resolve their dispute via Rule K. The High Court case was therefore stayed pending the referral to arbitration. It is conceivable that in a case where proceedings are brought in another forum, the FA might impose a sanction for failing to comply with Rule K, though in my experience, that's unlikely to arise, particularly if the other proceedings were at least brought in good faith.
I'm really stretching the boundaries of my legal knowledge here with you two guys on the call. Am I correct in my understanding that with regards to, shall we say, that the FIFA DRC, there can be an opt-out in that situation where both parties agree that in the case of a dispute, they can opt out of it being heard by FIFA's DRC in favour of a national DRC? And on that basis, is it possible for two participants in a football dispute that would normally be subject to a Rule K, for them to jointly opt out of Rule K and seek a resolution via another mechanism?
This is quite a legally complex area. Ultimately, it is possible for the parties to reach an agreement to resolve their disputes by an alternative mechanism. However, it would have to be made explicitly clear in the contract between the parties as to what exactly their agreement is in terms of their dispute resolution model. That's because there have been a number of examples in the case law where parties have tried to bring proceedings in the civil courts, but have been sent back to Rule K arbitration because the court has found that there's been a binding agreement, whether express or implied, between the parties that subject them to arbitration under the Rule K process. But it is possible, using the correct terminology and the correct provisions, to make alternative arrangements in the contractual arrangements between the parties. That might include going as far as opting out of any football dispute mechanism whatsoever and reverting to the ordinary courts. That might be a possibility as well. But that's a yet further evolution of the argument and requires ultimately specialist advice to make sure that your contractual arrangements are befitting of the purpose that they're intending to achieve.
What type of agent disputes have been heard or ended up at Rule K arbitrations over the years?
Well, I think as our discussions made clear, the scope of Rule K is very wide indeed. It encompasses any and all disputes between participants who are subject to the procedure, any and all disputes. So agents may find themselves, for instance, in dispute with clubs over introduction fees. They may find themselves in disputes with players or ex-clients over unpaid fees for services rendered. They may find themselves in dispute with another agency over the rights to a particular player. There is really no limit on the kinds of case that agents may find themselves involved up in FA Rule K arbitration. Generally, they are commercial matters arising out of contractual relationships and alleged breaches of contractual relations.
Now, if somebody listening finds themselves as a respondent to a Rule K, they get that notification dropped through the door, or maybe if they're an agent and one of their clients, whether it be a coach or a manager or a player, gets that paperwork dropped through the door. And Peter likes these double-pronged questions. I've got a triple-pronged question here. What, firstly, should they do? What should they consider in how they approach the situation? And how would you recommend they prepare for the hearing moving forward?
Well, I'd say there are two golden rules which run through each of the three prongs of your question, Jonathan. Golden rule number one, don't panic. Golden rule number two, comply. Don't panic if you find yourself in an FA Rule K. There are sources of help and advice available. The FA's rules on the procedure are easily accessible on the FA website. They're not too lengthy and well worth reading. Plenty of open access resources online as well. And I recommend taking legal advice. Sports solicitors, sports barristers are well used to dealing with the time pressures of the industry. In terms of complying, always make sure you're complying with any orders or deadlines that have been set in the arbitration at the point that you are brought into it, or seek an extension of time if you need it. The biggest pitfalls always arise when directions are missed, deadlines are slipped past, and the effects tend to snowball. In terms of specifically your question about preparing for a hearing, well, it's important to know your case. That's the most important thing. Know your case back to front. Know the evidence, know the other side's evidence, know what you want to say, preparation, preparation, preparation. Of course, if you have professional representation, you'll be guided through that process. But it's absolutely important to be prepared at all stages and to have assessed the merits of your case.
And of course, there's a good guide on Littleton's website as to all aspects of Rule K, which if people need to refer back to, we'll put a link in the show description on that. Joe, thank you so much for taking the time to explain it further to us. I'm certainly a lot clearer than my first experience of Rule K many years ago. So thank you very much for your time. Thank you very much for your expertise. And I'm sure that's been very useful to many of the listeners.
Thank you very much.
So hopefully that explanation of the Rule K process by Joe gives some clarity on why a decision over the new agent regulations in England may have taken so long. And also, more importantly, it gives a valuable insight into the Rule K process should anyone find themselves subject to Rule K because of a dispute with another football participant. But even though the Rule K process has provided a ruling on FFAR in England, what happens next? If we have no caps enforceable on agent regulations permitted under FFAR in Spain and England, two of the biggest football markets, and an injunction in Germany that halts not just the caps, but the whole of the FFAR, this is going to surely result in aftershocks around the world. So will this trigger the release of more long-awaited national football agent regulations around the world from various football associations, possibly without a cap? And will some who have already released their NFAR subsequently adjust them?
I will say one thing, Jonathan. If the FA publishes agent regulations going forward, it will keep one thing, a Rule K arbitration going forward as part of any regulations. But going forward, as with many arbitrations, and Joe pointed this out, most of the details may well remain confidential, so we may not get all that. But I think everyone, including agents and the Football Association as well, would welcome the clarity that's been provided by the decision that's been made. But I think that this decision may preempt other football associations to release their national football agent regulations, but also the ball is in FIFA's court to give guidance on what should happen now, whether there should be a moratorium, whether there are going to be changes. I would say it's crunch time for all stakeholders.
As I think I've mentioned before to you, Peter, the suspicious and sceptical side of me thinks that the outcome of the Rule K in England may actually suit both parties to the dispute in some ways. And there were some rumours circulating several weeks ago, if not months ago, that the writing was on the wall with the decision, as we found out yesterday. The first question is, did the English FA really want new, highly problematic and contentious regulations to implement that may cause them more problems and conflicts with agents as well as an increased workload? Also, we wait to see whether the FA in England will try to retain some form of national registration and agent fees, as this was promised by some at FIFA not to be the case. There would be a FIFA central fee, and then there'd be nothing for national registration. But seeing as there was significant revenue in intermediary registrations at the FA, possibly millions of pounds since 2015, they may look at that. Also, I've heard from FA officials in the past that they have always avoided agent regulations that will put English clubs, if not agents, at a competitive disadvantage in terms of transfers. The agents definitely didn't want the FFAR. That goes without saying, and they definitely didn't want it implemented in its entirety. And arguably, the cap was at the top of their list of objections in this English Rule K. We don't know for certain, but I think it's a pretty safe guess. What does FIFA do next? We've already said that's anyone's guess. Under normal circumstances, a sensible person or organisation would consider their options, whereas some may define labouring the same point and expecting different outcomes some 5 years later is a sign of madness. We heard from the likes of Gregor last week and Rodrigo in episode 19 that in the likes of even Germany and Spain, where rulings had been made, they were also watching intently to see what happens in England with the Rule K decision. Does the combination of these three markets absolutely cause a FIFA rethink? As ultimately, I would say it derails the capping element of agent commissions at the very least in FFAR.
What I'll say, Jonathan, is the state of play in the big five markets has really changed the way the whole regulatory space is going to be. We saw Germany, no FFAR, Spain, no cap, England, no cap or no pro rata installment payments. France, there is a state law. The French FA had a look at the FFAR, they changed a few points, but they actually do have a cap, 10%, but they will not follow the 3% cap of FIFA. And one of the motivations I hear is that a lot more of their good players from the French leagues would go abroad. Then Italy, the last of the big five, they have a national law, which I think came in on the 1st of January 2023. But they're still waiting for the federation to provide the regulation, which will include both FIFA's regulation and their national law. So as in with France, national law plays a role here. And they're also waiting to see what happened in other cases, especially the Rule K arbitration, but obviously Germany and Spain. I know there's a meeting soon in Italy to clarify a lot of this position, so we need to await what's going to happen there. But right now, the landscape is fragmented and we need someone to step forward with some clarity. And I think right now, FIFA may need to take the initiative and say, these are our next steps in terms of how do we deal, especially with these five big countries, but also what's been happening in the last few months and decide for everybody's sake, where do we go now?
One would hope in terms of the English FA, they would have a plan A, a plan B, if not also a plan C, based on what the outcome from the Rule K would have been. But from past experience of the FA, planning, preparation and foresight is not their strongest points when it comes to agents and agent regulations. Personally, I think we will see the FA implement as much of the FFAR as they can to appease FIFA in some stripped back form, whilst accommodating the Rule K ruling and, of course, national legislation. However, we do have some hints as to what may happen with regards to national football agent regulations in England. Much like Joe's interview on the topic of Rule K, which we have held back for several weeks in anticipation of the Rule K decision, we have also been sitting on a copy of the proposed national football agent regulations from the FA, and this is from roughly 5 months ago. As I mentioned, this was released to a seemingly very small and selective group of people several months back, and probably was something that prompted the Rule K challenge to the new regulations in England. So if I may, Peter, can I just go through some of the observations I made back then in regards to the proposed NFAR from the Football Association? The FA may well go back to the drawing board on these in light of the Rule K decision, but I think it is safe to say it gives us some idea of what they may have in mind. So the first thing I noticed in this document is that it states the FA will review and consider the feedback provided and finalise the NFAR. So we are potentially back to the criticism of FIFA with the FFAR as to what is considered adequate consultation, as there's no mention in here of acting on any feedback or any further discussion. I would hope in light of the Rule K challenge, the FA will undertake proper and meaningful consultation with agents in what they do going forward. It also states that the FA are only seeking feedback on the additional measures. So I'm taking from that, it's the additional measures that weren't part of the RWWI and aren't part of the FFAR. Now, this tone I'm disappointed by. I'm not surprised by it, but I'm disappointed by it, as I think this is a missed opportunity to actually address other notable issues and problems from the era of RWWI, the regulations on working with intermediaries. It seems like a sticking plaster approach, rather than seizing the opportunity to raise the bar at this time in terms of standards and regulation and really improve things for all participants.
You mentioned there was engagement in relation to the proposals for the National Football Age regulations in England previously, before obviously the decision was made on the Rule K arbitration. I think right now, very important point, need to improve things from here. The FA will have to engage with maybe the English Agent Association, AFA, the litigant agencies, the four that took this action, other important groups in relation to the outcome of the Rule K arbitration. What is in going forward? What is out? The English agents will demand certainties because the transfer window is coming up. English agents who pass the FIFA exam, what happens to them? Foreign agents who want to work in England or working in England, what happens with them? The German link. There are so many different issues that need to be addressed, and this does pose a challenge. But I think as we will go through, we've seen, although the caps are out, although the way agents are being paid are out, there is an opportunity for the FA to develop the rest of the architecture of the agents' regulations to be positive and assist everyone in getting on with the business in a fair and equitable way.
You've already covered aspects of the competition law elements in this episode because the Rule K, we believe, was focused primarily on competition law in its arguments. One thing we have to consider with these proposals that were released is that there seems to be another legislative problem with English law. I hope this has been ironed out whilst the Rule K process was ongoing, but maybe not. And it mentions question marks and uncertainty over the Employment Agencies Act of 1973 as to where the football agents may be seen as operating in ways similar to that of employment agencies, and the legality around payment by clubs and players in cases such as permitted duality, dual representation. So if UK legislation and law dictates key parts of the FFAR conflict with national law, this could again be another big problem for FIFA and FFAR.
We've seen that EU law, European Union law, German law, French law, Italian law all apply on the FIFA football agent regulations. Thus, I agree with you, Jonathan. Any relevant UK law, like the one you just mentioned, also applies here. We even saw in previous episodes where we discussed the Swiss and the Belgium national football agent regulations that in Switzerland, the law said you also needed a job recruitment license. In Belgium, you had to comply with anti-money laundering legislation. So it is applicable that other legislation can apply to the agents industry. However, I think the Football Association would take legal counsel on those issues and address those within any regulations going forward.
A couple of more standard points, shall we say. Point 2.5 actually says the agent's registration is for an indefinite period, as with FFAR, probably because it is tied to FFAR registration in these proposals. You have to be FFAR registered to be FA registered agent. There's no mention of a registration fee for national agent registration, which matches what FIFA have said. But as I've stated previously, I feel the FA will be trying to make up for some of those revenue losses from the previous era, as they are quite significant. Point 4.7 confirms that FIFA will be producing a standard representation contract, which we've heard about from several months ago. But when and how robust this will be is questionable. After all, what we have to remember is that the FFAR have been implemented now for what is a few months, and nothing is yet confirmed from FIFA in terms of a standard representation contract.
We know that the template of a representation contract has been addressed at the FIFA Agents Working Group, that a template was going to be created. And that we know from the FFAR there are 5 minimum conditions that need to be in any contract, plus the condition of players taking independent legal advice as well as part of that. Agents need some sort of template where they can build a very good contract for themselves, a fair contract for their clients, and incorporate all the necessary clauses in order to operate in this environment. However, that's going to take a bit of time, and obviously with the caps situation, how is that going to be reflected in any contract? But I think a template will happen, and it'll come through the FIFA Agents Working Group. We may even see something in the December meeting.
Now, onto the topic that's very important, and I think everybody we've spoken to about FFAR agrees that the elements on the protection of minors are important and are welcome. But for me, there is a clause in here, or a definition from the FA, that I consider to be really overcomplicated. For those like yourself, Peter, with a legal background, this may be quite straightforward. However, definition under 5.1 in this document, I consider to be rather overcomplicated for approaches and agent representation agreements with minors. And I would argue, and you might see something different, that this arguably conflicts with FFAR regulations.
I think two things here. Every country has got laws in relation to younger people, minors, and the way they are safeguarded, the way you can approach them, when they can be employed. Now, I have had a look at the draft that was in the National Football Agent Regulation paper, and it pretty much mentioned any approach to a minor or their legal guardian, being parents, in relation to any football agent services or other services shall not be made before the 1st of January in the academic year in which the minor, the young person, reaches the age of 16. Very legalistic, but very definitive. But don't forget, a lot of times here, there's also commentary, where commentary accompanies a lot of these provisions to explain exactly, or Q&As. And we've seen that with FIFA providing Q&As, question and answers, with their regulations, the agent regulations. I think the same thing would apply here. You have a technical provision, but there will be commentary to break it down.
Don't get me started on the FFAR FAQ, because I think part of that actually conflicts and contradict the documents it's meant to answer questions on, but we won't go into that now. Another point is that it appears in 5.6 that agents will require additional authorization from the FA under NFAR to represent minors to that they get from FIFA. So there'll be 2 levels of authorization to represent minors, one from FIFA and then one from the FA in England. There's mention also of additional CPD, continuous professional development, under 5.7 in regards to representing minors. Now, this again is in addition to FIFA, we can presume, and this additional CPD is welcome in my opinion, because in all honesty, I don't think the FIFA CPD module on minors is the best or the most robust. It may well improve in time. However, the mention of CPD by the FA in England when it comes to agents is something that really grates with me. And I mean it really grates with me. As going back many years, I and others recommended and requested this from the FA, even before 2015. And one key area was working with minors. Safe to say, repeatedly, they weren't interested or didn't feel it part of their remit. And they actually thought it should be the likes of the AFA, the Association of Football Agents, who should provide this to agents. Maybe FIFA, with their CPD modules, albeit limited in their current form, have prompted this rethink on CPD for agents with the FA.
We got a lot of feedback from people who sat the FIFA exam that a lot of the questions were about safeguarding, and especially in terms of the FIFA agent regulations, how to protect minors. With every country being different, CPD modules are important for that context. And I think here, if the laws in relation to minors are strict, then the Football Association should work on providing one of those CPD modules. The other thing is, you've got to remember as well that there are other things that agents need to know here. The RSTP, probably the most important piece of FIFA legislation, has requirements about minors. If you want to bring a minor from overseas, you've got to get the FIFA Player Status Committee to approve the application. We've got EU rules for minors between the ages of 16 and 18 when they can move. This is a very important issue, and I think that any CPD module has to cover the whole gamut of protection of minors and providing support when they move clubs, move countries, and move for opportunities.
And I'll refer to a final point when it comes to minors here. And it seems the next observation is somewhat intriguing, as even the FA were undecided here when making these NFAR draft proposals. Now, under 7.10, it refers to the service fee in relation to minors, and it seems that this is undecided. And this was quite a bone of contention since 2015, and understandably a delicate topic when you're talking about service fees charged by agents in relation to minors. Now, the FA have seemingly provided 3 initial proposed options to consider here. Does this mean they are letting the agents decide, or just making it seem that way? And if they are letting the agents decide, which agents will decide? That's a question. This was released to a very small group, and that isn't totally clear. Also, this may now seemingly be impacted upon by the Rule K arbitration decision, because we're talking about service fees for agents again. But I'll park that for now. One thing that I've always agreed with is that players, clubs, whoever, should be given the option to seek independent legal advice on rep agreements, and this is covered under 6.4a. When operating as an agent, if I presented a player with a rep agreement, I always said to them, go and seek advice, go and take time, consider it. Not everybody does that. We know that. The current footballing landscape doesn't always accommodate the opportunity for somebody to seek that independent legal advice. We know it's been changed in the FFAR, that they do have to seek it or declare that they have chosen not to seek independent legal advice. There is actually direct mention of the PFA in this. Now, personally, I would welcome the PFA but under different circumstances whereby they have no conflict of interest in agency activity, to provide this independent legal advice, or a totally independent provider provides such for a fixed fee to players. I'd even go as far to say it should be mandatory, let alone voluntarily under FFAR, but that's my own personal opinion. I don't know what you think on that, Peter.
I'm going to be short on this. The PFA in Australia, my home country, provides legal advice for players, including looking at agent agreements that they may sign. I don't think there is a conflict issue here. In most countries, if there's a players' union who can provide that advice, that's cost effective and straightforward, because sometimes also when you go to other lawyers who are not experienced in the space, they incur costs, they'll drag things out, and they may come up with a lot of things that are not relevant because you need experience in this space. And I think the PFAs, they know the representative agreements, and if they can provide the independent legal advice to the player, then that should be the best way. Obviously, there are the football lawyers or sports lawyers who can also provide that as well. And maybe a panel can be set up to avoid what you just mentioned about conflicts of interest. But I'm all in favour from an efficiency and a certainty angle that the PFAs provide totally independent legal advice to players before they sign their agent agreements.
I totally agree, Peter. I think what I'm getting at there with the PFA in England for a long time, they've been seen as a rival to a lot of agents in that they have agency or intermediary operators. And it's understandable that agents are very reluctant in such a competitive industry to send a client or a prospective client to somebody who might be considered a rival over such issues. But going back to an issue that Gregor mentioned last week, and we're going to talk clearinghouses. And this has actually been resolved in the intervening period since we saw this document. 7.5 provided reference to the FIFA clearinghouse for agent payments. And this is again in the FA's document. This point we're now clear on, and my predictions at the time of reading these proposals have now been confirmed. And the FA clearinghouse is no more, to my knowledge. However, as far as we are aware, the FIFA clearinghouse will not be processing international agent payments for some time, possibly 2 years or more, we've been led to believe. And for agent-related domestic payments, we haven't had a timeline on that from FIFA. So it may be many, many years down the line, if ever. So this clearinghouse element I commented on and asked the question, does it mean the FA clearinghouse is no longer handling agent payments? Is proved correct. Some people dismissed my observations at the time. Not you, Peter, I know that. But probably a couple of months later, I have been proved correct with the FA announcement that their clearinghouse ceases to exist for agent payments.
That's a very interesting move. I had a look at the national football agent regulations here about remuneration transparency, the draft, and it's shifting the focus. Example, and we know that a lot of the time the agents expect the clubs to pay on behalf of the players, or the clubs, if you're representing the club to pay as well. But it is actually looking at transparency from another angle. And in this regulation, there was a suggestion or a clause, I would say, that any and all remuneration or payments of whatsoever, whether direct or indirect, made to any person being the agent in relation to football agent services or on behalf of a club must be made by the club only and must be fully recorded in the accounting records of the club. So there's an emphasis now shifting to the club owners that they're responsible for reporting payment. So that's just one example in these regulations, because once you get rid of the clearinghouse, you need some other rules which make payments transparent and recorded and be able to be audited. And I think these regulations were there, that's one example, to cover the issue of remuneration transparency, because if you're not bringing back the clearinghouse, you still need to have checking where payments are made, who's making payments, and who's responsible for payments.
I think Gregor highlighted that in last week's interview, that how important it is that the process is right and everybody's assured in how the clearinghouse operates. But this might just be a hot potato that the FA wanted to lose and see somebody else take on the responsibility of a clearinghouse. As I remember, as far back as 2014, 2015, unofficially, some people in the FA who were directly involved with the clearinghouse on agent payments wanted to get rid of it back then. It was seen as a bit of a problem. Now, the final thing, and there are repeated references to this in the document, of international challenges to the FFAR. And it states at one point, the FA is not a party to any of those proceedings. So we saw the German FA, the DFB, pulled into the dispute in Germany and subsequently fined €150,000, as with FIFA, post the injunction there. And we heard Rodrigo mention in Spain, the Spanish Federation, the RFEF, were pulled into the case there, much to their consternation. So maybe that was the FA at the time wisely covering their backs in this sense, in combination with the Rule K proceeding. So that's just me picking over the bones of these primary changes that were released by the FA in Appendix 1 a few months back now. You know, Peter, that for me, my long-time suspicions were that the FA didn't really want FFAR. They didn't want NFAR. Pretty much are happy for the Rule K process to take the decision out of their hands rather than be caught in a crossfire between what seems a hell-bent FIFA and a very angry set of agents, and powerful agents in this case, of the Rule K.
Very powerful, very powerful.
So now the FA can stand back and say to FIFA, it's out of our hands, somebody else made the decision, and they can move forward. It's not an easy situation for them to be in. But what they do and when, nobody knows. But I hope that something sensible will be in place for February, once the January window has passed, in terms of NFAR. And in the interim period and thereafter, they accommodate both FA-registered intermediaries and FIFA-licensed agents operating in England. I don't know what you think of those, Peter. You've made your own observations on these FA, NFAR documents from some time ago. But as a lawyer, as an international agent who, like so many other international agents, will be affected by national football agent regulations in England, I don't know what you think. Plus, of course, you spent many months studying various NFAR from other countries around the world in regards to the FFAR and summarising them in previous episodes of the Agents Angle.
Jonathan, I had a look at the draft New English Agent Regulations, their National Football Agent Regulations. Obviously, they haven't gone ahead because we had the Rule K arbitration. I find them very interesting. Now, it's a bit like the FIFA ones, where there's some great things. If someone's signed exclusive with another agent, you can't induce to breach that contract, the protection of minors, CPD, as we mentioned earlier. But I also found some very good proposed additional measures by the Football Association in this draft paper. And I'll just go very briefly for our listeners in some of these. The registration requirements under the English regulations are formal and they morph into an undertaking where the agent has to comply with the National Football Agent Regulation. So it becomes an undertaking. That's quite strong than just registration. The interesting one for me is just cause. We all hear about just cause of a contract, whether it's a plain contract, but here we're talking about a rep agreement. But in England and as Australia, we've got English common law, and one of the big principles is a repudiatory breach of condition, in other words. Now, this is a bit more expansive in the sense that if you don't perform an obligation, the other party may be able to terminate. So they do mention this repudiatory breach in there, which is very interesting because, as we know, to get out of a contract by a player from an agent, it can be quite difficult. There's a few more things that I just want to go through. The English regulations allow for mandates and subcontracts, and that's part of this draft regulations, which is important because we don't hear much about mandates and subcontracts. So we know a lot of agents work with other agents and not only have the rep agreements, representative agreement with the player or club, but may need to use mandates with other agents to get the deal over the line. The other one is a very interesting one too, and I think we've got to see this across the board in all regulations. The English draft talks about an onus on clubs to educate their employees on agents, their football director, their scouting director, their coaches. A club shall use reasonable endeavours, it says, to ensure that its club officials and manager, coach, comply with the requirements of these regulations. Very specific. And we know that a lot of agents complain that third parties are interfering with their player relationships. So this is very important. And to finish off, it also deals with conflicts of interest in terms of private academies, and also that no club participating in the Premier League, English Football League, or the National League system may enter into any sponsorship agreement with a football agent or agency. And we know sponsorship can mean a lot of things. So that's another prohibition that's in those regulations. So I like a lot of these regulations, features which don't exist in the FIFA agent regulations. And I like a lot of these because I think it supports the agent business and provides a better architecture to the way we operate in this very competitive space.
Yeah, there's some good things in there, some progressive things, but we must point out that this was a proposal document from a few months back. I don't think a lot of the mindset would have changed that went into creating these. And I think it's great that the FA and the agents have got some clarity with this Rule K decision. And hopefully in the intervening period, the FA have continued to discuss various proposals with the agents, if not those have actually been in dispute within the Rule K. And we can all move forward and all have some clarity and work together on them. But England, whilst being a major football market, football is a global sport. It's a global industry with other territories having their own variations on football agent regulations. And everybody needs to keep that in mind. It's still a bit of a minefield. You're going to have to contend with different regulations in different territories moving forward.
Yeah, and it'd be very interesting right now with all these decisions in Europe, what the mindset is and perspective is, for example, of South American agents who are very active in the space, doing a lot of deals across Europe, Asia, the America, North America, MLS, how they're feeling about things. So it's not just about a Europe or a UK thing, although our episode's focused on England today, but how everyone's looking at things. And that's something also FIFA's got to look at as well to address the disparity in the way the application of the regulation is right now. So we've come to the end of the program and time to say farewell. If you've got any questions, get in touch with us. And we've got a bit of a teaser for the next episode. A lot of people have been asking us about Saudi Arabia, and we'll be discussing and having a guest on the Saudi Arabia or the Saudi Pro League. Bye from me.
Yeah, and a lot of work's been put into putting that Saudi episode together because it's quite apparent quite a few people don't want to talk about it. So take care, folks. See you next week.
The purpose of the Agent's Angle podcast is to provide news, information and facilitate discussion on regulatory matters, policies, business trends and issues affecting football agents worldwide. The opinions and recommendations presented in this podcast are for general information only and should never be considered legal or professional advice. Furthermore, the views expressed by guests are their own and their appearance on the program does not imply an endorsement of them or any entity they represent. Thank you for listening.